Good to catch up with you again. A month or two ago, I did a podcast on effectively selling your PropTech business. I was talking a lot of legal and commercial aspects that will be important for you if you're in the PropTech business, and one day hope that someone knocks on your door and wants to buy your business. We had quite a strong reaction to that podcast, and in it I skipped over a whole lot of legal and commercial issues, but the one that got quite a deal of interest was privacy and data. I'll come back and talk towards the end about some commercial data issues, but what we're really sort of focusing here is on the legal privacy and data issues, and that's often what actually is being sold in your PropTech business. So what I thought I'd do is get a real expert in this field. To my right is David Kreltszheim, and David is a specialist in this field, better known to me as Special K. So I thought we would just concentrate on, as I said, the legal issues associated with privacy and data, and hopefully that helps in your progress to an eventual sale if that's where you're going, or just keep your business tidy on the way through. So David, it seems to me that privacy seems to, as a legal issue, ebb and flow. Would I be right about that, or where are we at the moment? Yeah.
John, I think thanks, good to be here, and on your question, I think privacy has over the last 20 years ramped up in significance. It's true, I've been practicing in this space ever since then, if not a little bit before that, in the 90s, when privacy applied to the Commonwealth public sector and to banks. But once it applied to private sector organizations in 2000, the year 2000, initially it was a sort of soft burn for a long time, and you had a policy, you put it up, and over time things have become far more significant. I think there are a few sort of steps along the way. So in 2014 there were a whole bunch of amendments to give the Privacy Commissioner more muscle, as it were, for enforcement. And
so the Privacy Commissioner is the regulator, not ASIC?
That's correct. That's right. Yeah, that's right. So it's not ASIC or the CCC. It is a special regulator in the Office of the Australian Information Commissioner.
Right.
And I'm calling that regulator the Privacy Commissioner because in the May 2023 budget just last month, they've moved to revamp the organisation and have a dedicated Privacy Commissioner once more, which they did until about 7 or 8 years ago.
Is that been associated with the data breaches, the ramping up, or not, or just a general concern about privacy?
I think it's to do with the general concern about privacy and the data breaches, to have a Privacy Commissioner described as such, who is given a paramount place in the whole regulatory framework.
So, at the moment, is the Privacy Commissioner active? And if the answer to that is, what do they actually do?
Well, they've got a number of different powers in their kit bag, as it were, John. So they can react to a complaint that is made by a aggrieved individual and make a determination. Alternatively, they can, off their own bat, they can initiate an investigation and make a determination. They can seek civil penalties in court. They can issue infringement notices, and like the ACCC, they can obtain enforceable undertakings. And quite importantly, if you'd like me to go ahead with that, in December last year, the civil penalties for serious and repeated breaches of privacy were considerably cranked up.
Right. So the privacy laws, just an overview of that. So like we all hear about sort of privacy laws, and we'll come back a bit more to data. So what are the general sort of privacy sorts of principles that, if you're in a PropTech business, that might be relevant to you?
So you've got, John, you've got the Federal Privacy Act, which has a bunch of privacy principles in it, which regulates the handling of personal information at every stage of the so-called information life cycle. So it regulates how you collect information in the first place, what you've got to tell the individual when you collect that data, what you tell them about who you are, how you're going to use that data, how you're going to disclose it, if at all, to third parties. All of that has to be covered in collection. Then disclosure and use, that's regulated as well, that you can use and disclose that personal data or information for the primary purpose for which you collected it from the individual, or for a related secondary purpose that's within the contemplation of that affected individual, or you can get consent. So those are a few little parts of the building blocks there.
So I'm I think right here that that's really done at a documentation level. When it's like, I suppose I'll never read it. It says, you have to click and read our privacy policy before you can enroll, you can do anything, which presumably no one ever does, except maybe the Privacy Commissioner. So it's got all that legal requirement framework.
Indeed, and it needn't be a document. In this day and age, a lot of the privacy compliance is done through an online onboarding process, for example. So as part of populating a web form or going through a click-through, you can have the privacy disclosures that need to be obtained or given, or you can get consents. Even though consents, you've got to be very careful to make sure that they're informed and valid in how they are obtained. You can't sort of bury something on page 33 of a long set of terms and say, we've got consent. So there are certain basic elements of hygiene, as it were, in how you document your process flow to comply with the requirements of the Privacy Act.
Can I ask you this question? We sort of see regulators, not in the privacy space, but around the country, the state regulators like Fair Trading in New South Wales or CAB in Victoria, and all the other states have got their own equivalents. Does the Privacy Commissioner, if I can put it this way, investigate the small guys? Like if you were just a relatively small business, can you get investigated? Does that happen, or is it really they'll prosecute names everyone have heard of? Or?
That's an interesting question, John. And it's true to say that, for example, with data breaches and so on, the tendency is to prosecute or take action against some of the bigger players, especially before the notifiable data breach scheme came into effect in 2018. Before that, the Privacy Commissioner had a name and shame jurisdiction, and that name and shame jurisdiction, it was exercised in 2011, 2012, 2013 against some of the really big players in the market like Sony, PlayStation, and players like that. But the law is the law. So I think the Privacy Commissioner would say that regardless of the size of the player, you would be on their radar. If, for example, a complaint is made, it doesn't really matter what the size of the organization is, that organization would be investigated. Now, I must also add, there is this, in the Australian privacy law, as far as I'm aware, there's no equivalent elsewhere in the world. There is this concept of a exemption for small businesses with an annual turnover of under 3 million. Subject to some exceptions. If you are in the data handling business, that exception won't apply. but there is an exception that's available. And so if you're within that exception, then the Privacy Act technically does not apply to you.
Right.
However, in the last 6 or 8 or 10 years, it's really not been a good look for any business to try to rely on that exemption. So I know when I last looked some time ago, there's a bunch of around over 500 organizations which are technically small businesses, which have nonetheless gone to the Privacy Commissioner and positively opted in to being regulated.
Yeah, okay.